use mediation as a tool through in business divorces. So one of the first things I'd like to start off with is what mediation is and what it isn't. There are a lot of misconceptions out there in the general population about what mediation is. First and foremost, it is not meditation. People oftentimes think that it's meditation. It is not. Mediation and meditation are two different things. Mediation is facilitated confidential negotiation. With a very few exceptions, most states have laws in place that protect the confidentiality of discussions that occur within the mediation context. The parties basically enter into a contract to mediate, and the parties agree under those contracts to keep matters confidential. And that is one of the best things about the nature of mediation. You can get a lot done in a way that's very private and confidential. And what do I mean by facilitated? Facilitated conversations basically are those where you have a neutral party, the mediator, who helps the parties sort through the issues, figure out an agenda, and figure out exactly how they can structure the dialogue to maximize their productivity and to maximize the potential for agreement. So the parties will generally jointly select a neutral third party to serve as the mediator. Oftentimes what will happen is one side will propose a slate of names, the other side will propose a slate of names. And if there's a name in common, that person will be selected. If there isn't, then they will go through several rounds of figuring out who is acceptable. And this is actually a very important part of the selection process. Who you choose as a mediator sets the tone for all of the discussions. If you pick someone who is very evaluative when you are dealing with parties who are more relationally based, things can go very wrong. Conversely, if you pick somebody who is too touchy-feely with parties who are, let's just get straight to business, and very evaluative, you may not have the best fit. So looking at the personality of your mediator is a really good thing to do when selecting one. So the mediator, first of all, has to determine whether or not they can be neutral in a particular matter. And that's basically, did they have a relationship with one of the parties such that they don't feel that they can remain unbiased. If the mediator determines that they can be neutral, then the mediator and the parties discuss what should the process look like. And the mediation process can be very different from situation to situation. So in a number of the mediations that I work on, we're basically in and out in one day. We schedule either a 2-hour, 4-hour, or 8-hour window, depending on how convoluted the issues are, and we do all the work in one day. Other cases, however, the process is better served by splitting up the conversation over multiple days and into multiple parts. Business divorces often fall into that category because very typically there are a lot of issues to talk about, and there are also other professionals that need to be consulted, such as tax professionals and financial advisors, to make sure that the process is going forward in a way that serves the tax and financial needs of both parties. So oftentimes when it's a business divorce case, unless the issues are really, really narrow, I will frequently suggest that we do so in a staged approach. So the mediator can conduct one or more sessions as the mediator feels it is necessary. Those sessions can sometimes be joint sessions where everyone is present. Those sessions can also be separate sessions. Typically, mediations will involve a blend of the two. The parties will often start out talking together, and then as issues become more contentious, the mediator may choose to separate the parties into two separate caucuses where you can have slightly more frank and open discussions about what your interests are without feeling that you're jeopardizing your particular negotiating posture. And in those sessions, there's another layer of confidentiality. So the mediator will ask the parties, is there anything you don't want me to share with the other side from these discussions? And if the party says, I really don't want them to know about this particular interest or need, then the mediator will not share that openly with the other side. The mediator may use that information to help frame the approach that he or she takes with the other side, but will not disclose the information that was shared. So what are some of the differences between mediation and unassisted negotiation? So negotiations that take place directly between the parties, either the parties themselves or their lawyers. So unassisted negotiations, there's no additional cost. Obviously, if you have lawyers doing the negotiating, there is cost associated with that, but there's no additional cost besides the cost of the attorneys if you choose to hire them. Unassisted negotiations can be very quick if the parties are in agreement on the majority of the issues and can sort of work together collaboratively to get to yes. Unfortunately, that's not a very common fact pattern. The downsides to unassisted negotiations, one or both parties can leave the process feeling unheard, and that is a tremendous downside. Oftentimes, those are the situations where folks end up bringing up issues after the deal has been struck in principle, or bringing up issues after the deal has actually been signed and saying, wait a minute, there was fraud involved, or there were inducements provided that make this deal unfair in some way. And that's when you may end up in litigation post-deal closing. A second reason why unassisted negotiations can be problematic is because emotion will often trump reason. And this is particularly problematic when you are dealing with closely held businesses, family-owned businesses, where there's been a tremendous amount of relational interaction between the parties. Their emotions regarding the way they were treated in the relationship can often trump their ability to sit down and take an objective look at the numbers and the facts that are involved. Parties also, when they're in unassisted negotiations, tend to focus on winning rather than building consensus. So rather than looking toward what have we already agreed on and hey, look how much work we've already done, they're very focused in the moment on having to win that particular battle. Mediation, on the other hand, can take some of that need to win out of the equation. Finally, unassisted negotiations are often less organized, and so there's a greater potential to get sidetracked into the problems as opposed to into building consensus. So mediation does the reverse, and we'll talk about why in a minute. Mediation is conversely very focused. The mediator will set the tone and set the agenda. Often the mediator will let the parties sort of guide where the conversation goes, but the mediator is the one who will decide, okay, if there are these 5 issues, let's talk about what issue we're tackling first. And the mediator may suggest, and often does suggest, tackling the issues that build consensus and that are going to be easier to agree upon first, so the parties feel like there's some momentum building in the negotiations and discussions. That's extremely useful for making sure the parties reach ultimate agreement. Conversely, the parties themselves might try to start with the most difficult and the most contentious of issues. And that's a guaranteed recipe to have the parties walking away from the table at the end of the day, rather than being committed to doing the work to getting to yes on both sides. Because the process is directed by a professional neutral, both sides get the benefit of a neutral's analysis of the situation, and get the benefit of someone asking them hard questions about the postures and positions that they're taking. One of my favorite techniques in mediation is to ask open-ended questions that really ask the parties to think deeply about what it is that they truly want, what it is that they truly value, and what it is that they're truly giving up. Those questions tend to be really useful in getting the parties to move past positional, we call it, thinking, and look more towards interest-based progress. Another benefit, particularly if the parties don't like one another or have trouble communicating with one another, is there tends to be less contact in mediation with the individual or entity with whom one is in conflict. And that can really help people make better decisions more quickly. It takes that emotional piece out of it to some degree, and it allows people to look at the facts and figures and the realities of situations in a very different way. The communications are also filtered. So in room 1, somebody may tell me, yeah, Joe Schmo is really stupid, ran this business into the ground, and doesn't know what he's doing. I can take that and go into the other room and say, well, they really feel as though that there are some improvements that they can make to the business operations and structure. They appreciate what you did, but they think that the business needs to go in a different direction. Two very different ways of saying pretty much the same thing. One is going to set somebody off and cause them to become more entrenched in their position. One is not, and that's the benefit of having the filter. Parties also often hear and absorb information more effectively when it comes from a neutral party as opposed to someone in whom they really don't have any trust any longer, in whom they, in fact, may have serious distrust. So coming from a neutral party, the very same sentence or idea may have more, may be given more credit and value than it otherwise would. And finally, a mediator can gain insight into areas of common ground, allowing the parties to recognize where they may be able to work together in ways that they might not have thought about. Those confidential conversations can be very telling. When I go into a particular room, one side may have been saying to the other all along that they really, really have to have this for a deal to go forward. But in that private conference with me, that consideration may be found to be third or fourth on the list of true priorities. And when I go into the other room, they may also have something that they've been shouting from the rooftops as their most important point that really isn't the most important thing. And I can take that list of priorities from each side and start to figure out where we can start to work together. Several misconceptions about mediation. First of all, a lot of people think that it can only be used for conflicts that are in litigation, so when parties are suing one another, and that is not the case. Mediation can be used at multiple stages. It can be used very early on in a conflict. It can be used at the end of a conflict. It can be used somewhere in the middle. So oftentimes it's not a bad idea to talk with a mediator when you see a conflict emerging and say, hey, is this the right time? Oftentimes a mediator will say, you probably don't need me yet, but keep me in mind when this happens or when you get to this stage in discussion. The second misconception about mediation is that it's expensive, and typically it isn't. My daily rates for per party are about $1,500 and $1,500. So that's roughly, if there are two parties involved, that's $3,000 split between the parties. It involves 8 hours of mediation plus a couple of hours of prep work and a couple of hours of wrap-up work. So overall, it's compared to the expense of litigating, it is really not particularly expensive. And there are some mediators who are more expensive than I am, some who are less expensive, but it is definitely nowhere near as expensive as people think. Another thing people think about is that it's time consuming, and there are lots of different ways to structuring a mediation, as I talked about. It can literally be 1 day's worth of effort. It could be an hour here and there over multiple days and weeks, but it is not typically as time consuming as you might expect. You also don't need to have lawyers in mediation. I will often work with unrepresented parties. I cannot provide them with legal advice, and I do advise them that they need to contact attorneys if they want legal advice, but I can work with unrepresented parties and do so on a regular basis. Some people think it's too touchy-feely, and quite frankly, the way each process is developed is based on who's in the room. If I'm dealing with two highly evaluative, very professional, judgmental types, I'm going to handle that mediation in a strictly business-like fashion. If I'm dealing with a plaintiff in a personal injury case or a sexual harassment case who really needs to be heard and have their story told, I'm going to handle that very differently, and I will be more touchy-feely. I will be more relationally based. So the circumstances of the case really do dictate how emotional the conversation is, and the way it sort of progresses. Another misconception, and I touched on this earlier, is that everyone needs to be in the same place, and that's not true. I've been mediating over Zoom for months now, 15 months to be precise, and I've yet to have a situation where the parties have been in the same place. It's very easy to mediate with people in multiple locations, and it's very easy to mediate with people who separately. So if I've got two parties who really cannot stand each other and cannot be in the same room with one another, we don't have to have them in the same room with one another at any point in time. The last misconception is that it only works between two parties. So if you've got a circumstance where you have 4 or 5 individuals who've all been involved in running a business and they all have different interests, we can mediate that. It doesn't have to be one side versus the other. We can mediate with each interest group. So applications in business divorces. Common scenarios are disputes over valuation, disputes over control and ownership of real property owned by the business, disputes over control and ownership of intellectual property, disputes over allocation of assets and liabilities, and disputes over buyouts and exit terms. These are very, very common. And what I can tell you up front is that if you have done really great work on the front end with your clients and they have buy-sell agreements and all of those things in place, 9 times out of 10, if you need to involve someone like me, it's only on a discrete issue or two, as opposed to all of these issues. If you do not have the right agreements in place, we are going to be talking about all of these different things, and it's going to be a much more drawn out process and a much more contentious process, most likely. One aspect of mediation that most people don't know about is the concept of co-mediation. And co-mediation basically allows 2 professionals or more to work together as neutrals to help the parties reach agreement on particular issues. So I will co-mediate with other mediators. I will also co-mediate with other professionals. So it allows me to suggest bringing in, for example, if there's a dispute on valuation, I can bring in somebody who will serve as a neutral on valuation issues or tax issues, accounting issues, corporate law questions. That particular individual would not be providing advice and counsel to either side in particular, but rather to the relationship in general. So both sides could agree, all right, we want to bring in Amy, and we want to also bring in a valuation expert or a tax expert who's going to give us the real information on what the tax implications are if we divide the business up in this way or that way. So that is a possibility for some of your more complicated cases. And that's one of the reasons why I love provisors, because there are so many wonderful professionals within provisors that I can jump into community with and help work on cases that need those extra relationships. So you can benefit with the expert knowledge without having to go out and shell out the money for individualized experts. There may be occasions where you are going to want your own individual advice, and there's certainly room for experts from both sides to be involved in the mediation process, but their role is different from that of a neutral. So I've got an extra credit slide up here. There's a really great article that the Program on Negotiation from Harvard University put out about the role of mediation in transactional negotiations. So, and it also explains how mediation and arbitration can be utilized in business transactions versus in litigation. So that is that's something you can certainly take a look at. I can certainly email you the link at a later time if you would like. And now I'd love to turn it over to any questions that you may have.